31 candidates. Right, back to the Kenyan elections, which are just barely 20 days away, and the Independent Electoral and Boundaries Commission is still locked in a court tussle over the presidential ballot printing ruling by the High Court. Of course, they did lodge a petition at the Court of Appeal. They are still contesting that, and I am joined by lawyer Eddie Orindo to just put some of those issues into perspective, to find out where exactly we are in terms of preparedness and how much of legal bottlenecks are we in. Barely 21 days to the election. Thank you for joining us, Eddie.
Thank you, Ben.
All right, just if you can just take us through some of the issues before the Court of Appeal in this case.
Thank you, Ben, for having me this morning. I think I'd like to start from the point that a lot of clarity needs to be provided on what the actual issues are before the Court of Appeal. But even before I do that, I'd like to take you back just a little on what the ruling of the High Court was.
Yes.
And IEBC was directed to retender afresh and in fact comply with specific orders on public participation, which is where we have been between the time that court ruling was made and the time this appeal was lodged by the IEBC. And one of the first things I'd like to talk about is the purpose of an appeal. You appeal a decision of the High Court either because you're dissatisfied with a section of it or with the entire ruling. But I think we are presented with a lot of conflicts if you particularly consider official statement by Dr. Kombe of the IEBC last night during an interview here in KTN, in which she clarified that the purpose of lodging that appeal was to seek clarification on what the broad principles would be in determining the nature of public participation, because in fact the discomfort is that some of the procurement processes have been involved in, and particularly the purchase of specific material for the electoral process, may be open to a lot of challenge and therefore putting bottlenecks on the electoral process itself. But if you go back to the Court of Appeal, in which their lawyers have very clearly articulated their position, they have maintained that IEBC has very little time, considering there are only 21 days left. At the time of the ruling, they had 30 days. And that
by the time the Court of Appeal issues their ruling, it will be barely 15 days.
It will be barely 15 days, Ben, and that's the whole point. Because in my mind, and then speaking from a legal point of view, IEBC at the time that ruling was delivered has not been enjoying any stay, and therefore I was imagining, even in the event that they had to appeal for whatever reason, having been dissatisfied with a section of that ruling or the entire part of it, that they would still comply with specific orders of the High Court that public participation takes place. And I'm imagining a situation in which the Court of Appeal upholds the ruling of the High Court and public participation has not taken place. And we have even less days left.
Let's talk about this issue of the orders about public participation. IEBC insisting that in cases where it is direct procurement, you don't need public participation. What is it? Real stand?
I think I want to go back to something that the High Court made absolutely clear in its ruling, that there cannot be exceptions to provision of the law. And public participation is a constitutional matter. If you have to take that line of argument, then it would have made a lot more sense to ensure that the law is complied with from the very beginning, in fact dating back to February when similar directions were given that a retendering process is opened up. And we had close to 5 months at the time, maybe 4 months. Now we have barely 21 days, and at the time the ruling is going to be made, we're going to have barely 15 days. So that my view on this would be that public participation is not an exception. It has to happen. And again, the argument that it's not clear whether the High Court provided broad principles within which public participation may be interpreted is not entirely in good faith, because you only need to go back to previous rulings of the High Court on similar issues. And you can, if you like, look at the Kiambu case, for instance, in which the High Court made it very clear that exceptions to public participation cannot be made. And therefore, it ought to have started with a very basic interpretation of what that would mean. And in my mind, I'm imagining having a sitting with the stakeholders, not necessarily to make political considerations based on their views, but to give them an opportunity to air their views in as far as the integrity, credibility, and fairness of the process is concerned.
Let's talk about the issue of the time constraints. And we're talking about, we're expecting a ruling on Thursday by the Court of Appeal. This means, as we've said, it will be barely 15 days to vote to election day. What does this mean, without preempting the court case? Does this mean that IEBC will just have its way? I mean, 15 days is not enough to retender. I mean,
that's absolutely correct, Ben. And I think considering that lawyers particularly and a section of the political class have talked about a looming constitutional crisis, I still maintain the position that it's going to be largely of an artificial nature. And the reason I say that is no one is talking about the recent amendments on the Finance Act, for instance, that give the IEBC an opportunity for special procurement processes, for which they only need to seek authorization from the Public Procurement and Oversight Authority. In fact, if you take that direction, you would need a much lesser time than you would if you had to invoke the avenue of direct procurement. But nobody is talking about that. Instead, the positions that have been advanced before the Court of Appeal is that we do not have time, but at the same time, it has not been demonstrated how the orders of the High Court on public participation are being dealt with, so that in the event that the Court of Appeal decides either way, we are not in the perceived crisis. It's still possible to do the election. And then to come back to the question you've asked regarding what sort of scenarios we may be expecting, I think I must start by clarifying that contrary to positions that have been advanced, in fact, even by a section of lawyers, that there's going to be likely a caretaker government in the event that we cannot have elections on the 8th, I think that is very, very misleading and misplaced. Because if you look at the Constitution of Kenya 2010, the drafters did not anticipate a situation in which elections cannot happen, and I do not see any reason why those elections should not happen on the 8th. On the one hand, the exception you have is one that exposes the country to a situation of war in which there are very clear provisions under the Chapter 8 of the Constitution, allowing Parliament to extend by 60 days, a maximum of 1 year. If you consider the other possibility, and God forbid, under Article 138, in which either a running mate or a presidential candidate dies, then outside of those two possibilities, it is not possible, for whatever reason, to extend that election. So that it is very important for the country to begin to understand that the biggest mistake we are making, and I think I want to particularly address the lawyers on this one, is that we have put ourselves in a position in which we are advancing political positions before a court of law.
That is what I wanted to ask. Are the lawyers getting too political? Because we've seen those accusations of NASA wants a Nusumkate government by this. What is your take on that?
A Nusumkate government, as you put it in the first place, is not possible if you look at the manner in which the Constitution has been reconstructed from the previous crisis we had in 2013. And the mistake that is being made is subjecting issues of perception to rules of evidence. And I think even when NASA made these arguments before the High Court, they were expected to fail because of that reason. And the same reasons are being advanced before the Court of Appeal in the manner of a cross appeal. Now, if you look at the position of the IEBC, the same arguments that were made before the High Court are the same ones being advanced, that there's very little time, and that if IEBC is not allowed to conduct the elections under the circumstances that they have already explained, that there will be a crisis. And I want to make it very clear that should we have such a crisis, it will be one that has been anticipated and in fact engineered by political positions that have now found themselves before courts of law in our country.
Why is the Electoral Commission, why does it find itself facing so many legal issues in their preparedness for the election? They are a relatively new commission. Why do they find themselves in that position?
I think none of this has got anything to do with how new or how long they have been. But again, as I have said before in past interviews here, one of the things we need to critically examine is whether all the parties are acting in good faith. As I said earlier, and beginning with the IEBC, which is a constitutional and independent body, it has to be very clear that IEBC takes no instructions from any side of the political divide.
Right.
And that it has to be made very clear that public participation does not mean that they have to take the views of different political positions and implement them for purposes of political correctness. And that it also has to be further understood and very clearly that when you talk about public participation, you can choose to take part in it or exclude yourself from it. But as long as the opportunity has been provided for that to happen, IEBC would ordinarily be on the right path. The problem, however, they have found themselves in today is that they have failed to give guidance. And they have also failed to continuously explain why they're stuck to one position, which the High Court has also disagreed with in 2 occasions, and which is being increasingly questioned by the political players, so that it erodes the whole idea of an election being credible, free, fair, and that under the circumstances, should you lose, being very clear in your mind that it was a fair process. If you win, you win, knowing very well it was a fair process. But aspersions have been cast on the integrity of the IEBC itself, and I think the IEBC is making a bed that at some point it would have to lie on. So it would be very, very wise and prudent to begin to, first and foremost, comply with court orders.
All right. Yeah. Don't appeal court orders. All right.
No, I'm not saying you cannot appeal. However,
all right. But just all right. Thank you so much, Eddie.
Thank you.
That lawyer, just putting some of these legal issues into perspective. A lot happening on the election managers, the Independent Electoral and Boundaries Commission. That case, that petition is before the Court of Appeal. We are expecting a ruling on the presidential ballot paper printing ruling by the High Court this Thursday. We shall be keeping an eye on that for you. Of course, this is happening barely 21 days, barely 3 weeks to election day in this year's general election. Away from that, the Africa Movie Academy Awards saw filmmakers honored from across the continent